Neither rain, nor wind, nor sleet, nor snow will deter us from putting on Spin Legal on Tuesday nights.
If you say so, Angela. But
Yeah.
it's not snowing right now.
Well, not inside, no.
I hope not. I hope not. Otherwise, you've got serious trouble if it's snowing inside. Right, that's for sure. Okay, so welcome to Spin Legal, everybody. It is Tuesday night, 6 p.m., and that means it's Spin Legal time. Okay, so if you need any advice, you can call Invictus Legal on 905-688-5598. Email Angela at weareinvictus.legal, or me through Peter at weareinvictus.legal, or weareinvictus.legal is our website. Okay, so here's a question we were asked also by another listener. What actually counts as evidence in a claim?
Okay.
And you made actually the first point is your claim itself is not evidence.
Yeah. Like I can claim that Peter's an a-hole, and Peter does a lot of things. He stands in the corner of St. Paul Street on Tuesday night and sells certain things, certain drugs, all that stuff. I can make all kinds of claims. Then I could put it on paper and I could serve him with it and say that it upsets me. That doesn't mean anything. Evidence is when it gets brought before a court before an objective observer who can make an adjudicated decision.
Okay, and of course there's a lot that's going to go on between the initial point that you make your absurd, ridiculous, unfounded, slanderous, libelous, and defamatory claim that you really need to be strung up because of it.
Well, if it's put into a claim, a proper legal claim, and putting it into a court, you got some privilege.
Yeah, but again, the whole point about a claim is to win your claim, you've got to provide evidence.
Yeah, so you have to have evidence.
Yeah,
you actually have to have pictures of Peter doing all that stuff.
Yeah,
links to his OnlyFans page, all the stuff.
Okay, so the other question is, it's, for example, it's no use claiming that Joe owes me $15,000 without providing invoices to show that Joe owes you $15,000, for example.
Yeah. And going to court is just not a way to make money. Okay, you don't make a living by going to court.
Oh no, some people do, surely.
Yeah, like some people do sue for a living.
Well, actually, and that's becoming less of an issue in the United States today. It was a time that you'd go for, so basically, a workman puts ladder against a electric wire and gets fried in it. So wife goes and sues the ladder company for, bad workmanship.
Mm-hmm.
And wins $3 million or something, which means that she's set up for life and great. Hey, but the United States has stopped doing that kind of thing anymore now, haven't they?
Mm-hmm. Yeah, they have tort reform.
Yeah, they've gone through a lot of this kind of reform. So that kind of thing, but even so, that still has to be backed up by evidence. So the claim itself isn't evidence. Moving on, was weird. Okay,
I don't know
so
what happened.
Hide and show.
Yeah, neither is your defense.
And right, neither is your defense.
So you can say, I don't have an OnlyFans page. Prove it.
Yeah, exactly. Okay, so there's various types of evidence. And for example, physical evidence. Angela is accused of shooting her husband of 52 years with a shotgun, and so there's physical evidence. Now, whether you're going to bring the dead husband into the court to prove that Angela did it, quite another question.
Actually, it was only 50 years, so you're wrong.
Oh, okay. but again, at the end of the day, with things like that often physical evidence is reduced to documentary evidence. So you get
like a coroner's report,
yeah
experts, medical examiners. You'll have crime scene investigators,
yeah
people who would be on the site, and they would describe that, and you'd have photos of crime scenes.
and besides which she killed him on Mount Everest. Well, you can't bring Mount Everest into the courtroom, can you?
Nope.
So it's kind of there's limitations on the amount of physical evidence. Sure, bashed him over the head with a telephone, bang, bang, bang. Sure, you can show the telephone with a blood stain on the corner of it, type thing,
and have that tested and figured out whose it is.
Yeah, exactly. All of that sort of stuff could be used in physical evidence. Circumstantial evidence is another big area of evidence, and in fact, actually, circumstantial evidence includes, for example, the DNA that was on the corner of the phone where you bashed the person over the head with the and they took the DNA samples off the phone. So that's circumstantial evidence. It's also documentary evidence. It's also comes as part of expert evidence as well.
Yeah, and there could be motive, opportunity, and access to appropriate weapon, which is often what they look for in criminology. And and then does that person have an alibi? Nope. Because alibis are checked out. That's part of your circumstantial evidence.
Yeah, but again, things like there are certain types of evidence that have over the years. For example, it was Angela. I saw her at the murder scene. That kind of evidence has been questioned more of late.
Yeah, exactly. Because there's lots of red-haired ladies.
Yeah, exactly. And who's to say that that 39-year-old red-haired lady that is third from the left, number 3 on the lineup, isn't the same as the red-haired lady at number 5 on the lineup.
Yep, and even the lineups were challenged too.
Yeah, and so there's been a whole heap of evidence over the years where we no longer do it that way anymore. Circumstantial evidence basically means it's evidence that was based upon the circumstances of the situation. It's not necessarily a crime, because you could be talking about civil issues as well. For example, one thing you might be suing over might well be the bank statements, which is circumstantial evidence. It's also documentary evidence. So documentary evidence is the type of evidence that comes in the form of a document, often a written paper document like this, right, that has words on it, that has certain meaning. But the other thing, of course, is that documentary evidence could be electronic in nature, and could be like a computer program.
Yep. There could be a recording of a person's voice saying, yes, I owe you this money. Yeah. And it's dated.
Yeah.
Time stamped.
Yeah, exactly. And a lot of that kind of thing, where the voice itself is one piece of evidence, the metadata behind it, i.e. the timestamp, is another piece of evidence.
Yeah. But now with AI, it's starting to get scary, because sometimes they can actually create a voice and make it sound exactly like Peter. And then someone calls me and they say they're Peter, and I said,
I don't think so. I can see Angela right there.
What was that?
I don't think it's Angela, because I can see her right there, and she hasn't got her head. She's not on the phone.
Yeah. So these things are very interesting to look at, because and there's eyewitness evidence.
Yeah. But again, eyewitness evidence of late has been a lot less relied upon, hasn't it?
Yeah. Well, there's been some research done on eyewitness evidence where they can be easily fouled up on the stand.
Yeah.
Okay, where the car is red that hit them. So I tell them, I said, what color was the green car that hit you? You know, so I might say something like that. So
Agree.
it's easy to foul people up.
Yeah.
Okay? And also too, there's things that people don't remember or they can remember differently depending
Well,
on how much time has gone by.
exactly. Exactly. I saw, you know, for whatever reason, you get it in your head that it was a you know, it was uh, a red Toyota Camry, and I say no, it wasn't. It wasn't red. It was blue, and it was a Subaru,
Hmm.
right?
So
We've got
this is
two
where a
different.
lot of this would do. That's why there's a lot of more CCTV cameras around for certain things, and then the CCTV cameras could be called up and brought in, and see if there is something recorded. Hey, so a lot of times police would be after that. Like you've heard about things in the papers where they were going to businesses in the area and residences to see if anybody has cameras that could potentially have that
Yeah.
documented. So there's a lot of different things that things could be, you know, and it would either replace or supplement eyewitness evidence.
Yeah. Okay. Another one that's important there is expert reports, expert evidence, right? Because an expert, you know, you get some expert evidences comes in all shapes and sizes. You could have an accounting expert who might be able to identify to the inquiry, you know, to whoever's dealing with the inquiry about fraudulent activities that went on in the practice of the firm.
Yeah.
Right?
Yeah.
There might well be another expert that is talking about heart rates and the death, and another expert that talks about the time at which the murder occurred to their best estimate.
Mm-hmm.
All expert witness, all various different shades of expert witness.
Yeah. And there's ways that you have to get an expert admitted as a witness to make sure that the court would admit them and recognize them as an expert.
Yeah, it was interesting. You and I went to a trial where there was a documentary, a documentary evidence witness, a documentary specialist who put up evidence about a signature.
Yeah. And
Uh,
she was quite knowledgeable and had different machines and different things that she could use to look at things microscopically almost. And it was very
yeah,
interesting.
yeah, and she could tell that there were two, you know, that two given signatures were the same, because normally, even despite what we might say, we take to the bank and we sign our checks. They're all different. Every time we sign is different.
Yeah. There's no two of your own signatures even that are alike, even though
Yeah,
they're similar, but they're not the same.
yeah. And you think you've dotted the I's and crossed the T's at a particular point, but you haven't,
Mm-hmm.
right? So you
This is
know
big. Yeah.
so that's an important aspect about that kind of evidence. There's honestly, we could do a whole show about expert evidence on in and of itself, because experts, there's whole fields of experts. Everybody would remember the oh everybody will remember the My Cousin Vinny.
Mm-hmm.
Right? I think it's My Cousin Vinny, where they were doing this trial, and the woman gives evidence about how the tire tracks meant that it couldn't be a particular type of car because of how that car was manufactured.
Mm-hmm. Or
Right?
even the size shoes people have, you know, when they go into the crime scene,
Yep.
you know, whether probably likely to be a man or a woman. Hey. And there's even people who can tell whether the killer was right-handed or left-handed.
Yeah, that sort of stuff is fascinating because, in fact, for example, if the you know the position of head wounds, for example, would indicate as to whether they are left or right-handed, or even whether the attack came around, around from the front to the back.
Hmm. Yeah. And
Uh,
blood splatter patterns sometimes could detect that.
Actually, the interesting thing is I sat in a murder trial in England in the Old Bailey one time, and there was the evidence that was being given at the time, pretty gruesome, but was blood splatter evidence.
Hmm.
And they were talking about how the person came into the hallway of the house, based upon the position of the dead body, and the fact that certain blood splatter went up certain walls, but was shaded from other walls.
Hmm.
Because they more or less said that if a person had been walking past here and they were 5'10" and they leant down to chop at a person, the dead person, they could tell what type of weapon was being used. But if they chopped down at the person who's collapsing on the ground, because they could tell when they collapsed, so the knife wounds from the point when they were standing to the point when they had literally fallen on the floor, and they could tell exactly how high this person was based upon the shadow that they cast on the wall.
Hmm. Yeah. So there's a lot of that kind of stuff. It's very interesting. And then they have to be, so generally what happens is they're both used for both criminal trials and civil
Yeah,
trials.
yeah, and with evidence, it's all input. It's what is shown on the day
Yeah.
that matters.
But yeah,
Right?
and that's what is heard through the judge.
Yeah,
And generally, when an expert comes in, they are generally the court's witness, not generally a defense witness or a prosecution witness, but they are generally belong to the court.
yeah.
Anybody can call the expert up and or recall them, okay? Because they might have a question, because that's what specific information you're trying to seek out, okay, from that person, okay? And each side tries to prove their case with that expert.
Okay, so another one, which is main part of the way we run trials in under the English legal system, is what's called testimony under oath. So, um, can you tell me, Angela, about what happened on July 14th at such and such a location? Um, please, can you tell the court this?
So July 14th of what year?
Well, you're supposed to assume that I've given a year.
Yeah, yeah. So basically, that's what you kind of do, and then the person will give a recount of what they believed happened on that day. They would start from the beginning and go into the incident, and then talk about how it ended. Okay? And that's testimony under oath. And it could be your testimony, okay, that you're giving as a party, or it could be a testimony of a witness that you have. So
Yeah.
you can bring a witness in. The witness is similarly talking under oath and also would testify.
Okay, so here comes an issue, because you asked Tom, what happened on the 14th of July 2025 at King Street in St. Catharines. Oh yes, I recall that day exactly. This happened, and he tells his story, and then
Mm.
you get the defense brings on another witness later on that says, "Oh yes, I recall that day explicitly," and tells a completely opposite story.
And that frequently happens. Okay? So what happens is when somebody tells a completely opposite story, then, there's ways we can impeach that witness if you're on the other side and you want to kind of say, hey, you can't say he's lying, Your Honor. You can't say that. You'd have to step in and say, okay. He says, I've got proof here, sign-in sheets for these particular dates. He says, can you point out where your signature is? Right? And it's not there. Signature is not there. And I said, is it routine that you would sign yourself into a building or sign yourself in, when you come in? Yes, it is. But can you explain why you're claiming that you were there that day, but somehow your signature isn't? Right? So there's lots of different ways to go in, and then you kind of show that. It's part of the Brown versus Dunn rule.
Mm-hmm.
Okay, when you can do that, it's a right to cross-examine, to challenge any kind
Yeah.
of evidence,
Okay.
particularly when evidence is kind of like polar opposite.
Well, that's actually, of course, the worst piece of it, because in fact, actually, when the plaintiff's evidence, or when I talked about plaintiff and defendant here, when it comes to criminal cases, remember the plaintiff is the state and the defendant is the accused criminal. All right.
The Queen, Regina.
No, it's the king. It's the king today, madam.
The king, yeah.
I mean, Cousin Charles will be offended that you didn't know his name.
Yeah, or changing his sex.
Yeah, his sex is just. I mean, you will be courted, hung, and drawn.
Do they still have pillories in the town square?
The pillory machine, yes, yeah. Okay. So giving testimony under oath is, again, we could talk all day about just giving testimony under oath. Essentially, if you're asked to give testimony, you're asked for your view of what happened. You are expected to tell the truth. And if you're in the criminal court, there's a caution that says if you that you're expected to tell the truth, the whole truth, and nothing but the truth, and that you can actually be tried for perjury if you do not tell the truth.
It can also happen in a civil court.
Yeah, but you don't use what is called the civil. There's a civil thing that you use instead of the criminal.
I affirm or swear.
Yeah,
that I will tell the truth, full truth, and you put your hand on a Bible, or you just affirm.
Yeah, and in fact, most civil courts, they don't really utilize Bible anymore.
I actually saw one. They had 3 Bibles, different kinds of Bibles.
Okay.
So I guess they need to take care of the Abrahamic faith.
But also, then realistically, the civil thing is that you agree to that you are giving evidence, that you agree to tell the truth, and that failure to tell the truth could end up in perjury charges.
Yeah, exactly.
All right. And again, the problem here is with anything like this is that you swear it's a blue car and I swear it's a green car.
And that's a matter of credibility.
Yeah.
Right? That's very different than somebody who actually perjures himself.
Well, it's not.
Like credibility is, I can't. It's usually a factor of memory.
Yeah.
Maybe you remember it being a blue car, and I remember it being a red car. Okay. Yeah. But we both remember a car.
Yeah.
We both remember that. But somebody there will say, I don't know. I don't think the accident happened. I was there at the time. There was no accident.
Yeah, that's another thing that could happen.
There is a lot of that. Have you ever had a client go up on the stand, and then like they sounded perfectly well before, you ran them through all their testimony before and brought them into a trial, and then they get on the stand and then they forget everything.
Yep. Oh yeah, that's the worst. That's the worst. And actually, another day is that I had day one. I had the client on the stand, and they were passionate about everything that happened to them.
Mm-hmm.
Right? The trouble was, day 2 wasn't the following day. Day 2 was 3 months later. So then they're giving evidence as if it was the most boring thing in the world that had ever happened. And why am I being troubled to be here today, Mr. Adjudicator? And how can you go from up here, a very, very emotional...
Oh, I've seen that too. Like they're up at the height of passion because it's happening right there.
Yeah.
Right? Exactly. And then after they move out of their house, have to get out there, they found a new partner, got a new job, and everything's going well for them now. It's not even really important anymore.
Yeah. And that's part of the trouble about how long things take to get
Yeah.
through the courts these days.
Mhm.
Okay. So here's a big question, big important thing for evidence is how to introduce it. We already talked about the fact that just because you put a book into the court doesn't mean it's in use.
Yep, because I've had people one time when I was before an adjudication, and we use a portal to be able to submit things to the other side, so the other side can read it, adjudicator can prepare for the hearing, that sort of thing. And the person put like a ton of paperwork in there. And I just went around and I just did mine and I introduced all of my documents and all of my stuff and asked all the questions. The other side did not introduce any of the paperwork that they put on. They assumed that it was all going to be put in.
Yeah.
And then, of course, at the end of the day, I said, well, Madam Adjudicator, I said, I submitted this, I submitted that, we submitted this, and this is how we believe that the case should be decided. The other side claims this, but however, has not introduced any evidence into the tribunal because you have to follow certain rules.
And probably that individual who forgot to put the evidence pages up there was probably a rookie lawyer,
Yeah.
a rookie paralegal or something like that.
Yeah, I forget. I don't even know if it was a paralegal. It might have been just an individual.
Yeah.
Okay.
And in fact,
at that point, I was getting fed up with these self-reps, and I was having a hard time because some of the self-reps can really make your hearings a nightmare because it's not that they're trying to make it a nightmare. It's just that they don't know how to tell their story. Don't know how to do things. They get there. Nowadays, they're being a little more helpful. They kind of trying to direct people without necessarily giving them any advice.
Mm-hmm. Yeah.
So trying to direct. He says, do you have any specific item that you put on the portal that you would like me to look at? Okay, and please tell me what it is and why it's relevant and why I should care. Okay, that's the type of thing. Okay, so nowadays they're doing that. So it's very important that when you do it, that you do that. So evidence has to be properly introduced, referred to, and when in the court, we send people the documents 30 days before trial. We send everybody that document booklet with a list of our witnesses. And then I go at the day of the trial, I bring in Book of Authorities, which is case law to support everything, and plus a copy of my trial document booklet. So I make sure the judge has it, I make sure the other party has it, so that everybody is singing from the same hymn book. Otherwise, you're going to go to page 5 of, I think it's Appendix 9, or maybe it's Appendix 10. I don't know. Keep going through that. So everybody spends hours leafing through paperwork.
And again, going back to the original, evidence that was given as part of your claim. And by the way, there's a difference between, of course, how you do claims in superior court than how you do claims in the small claims court.
Yep.
In the small claims court, you're expected to put a bundle together, which might be 10 pages of your claims and 20 pages of your evidence that applies to the claim. In the superior court, you do not put evidence up under the one bundle.
You have discoveries for that.
You have discovery, yeah.
Yeah, and then they do discoveries. They do minutes of discoveries where they can ask that, and then the discoveries. Then you bring it to the actual trial or a pre-trial, and then there could be ways of settling it because that way there's no surprises. And then if somebody goes on the stand at a trial and they say something completely different than what they said during discovery, ooh.
And also with criminal matters, the Crown evidence is well known in advance.
Yeah, the Crown actually has to give full disclosure, Stinchcombe rules.
Yeah,
and they have to do.
The defense has to give a certain amount of notice on certain evidence, but not all evidence.
Yeah, like say if they want to do a plea guilty by reason of insanity, like not guilty by because you're not criminally responsible, or if they want to give a charter challenge, or there's different types of issues that the defense might want to argue, and they have to bring notice to that so so that the Crown can properly prepare for that.
But again, the reason that you have to give notice on those ones is because you're giving, like, for example, you gave them not sufficient mental capacity as part of your defense. Well, that has the Crown has the right to challenge that.
They have a right to challenge that, and the court can also order a psychiatric examination. So your client can be put into a psychiatric facility and examined, and a report being provided to the court will be available to both the Crown and the defense.
Yeah, which basically means that must be available well before the actual trial itself. So
so there's a lot of different motions and stuff like that go on before they go.
Yeah,
and I've done somewhat of that type of thing in certain things where I've helped out and I put people in, and I've had one guy who drove with a suspended license 5 times. The guy was a cocaine addict, and he had to rush to the bar, and he didn't have a way to rush to the bar without getting in his car and driving, but he didn't have a driver's license. It was suspended. And so all he knew is that he was sitting in the bar at that one time, and he was having a drink, and then he saw some police around. They were kind of eyeing it around his car and taking his license plate and walking around. And then suddenly they walked into the bar and they saw him. He says, "Hello, sir. You know why we're here." He knew darn well why they were there.
Yeah.
I got him off completely on mental health.
Yeah.
And addiction.
Okay,
but he had to go through what they call, where he had to go through a probationary period where he had to get treatment and things like that.
And the most important thing to be said in relation to evidence, there are rules in every single court about how evidence should be put up. Right? So what happens if there's going to be some questions about what happens if evidence is not introduced?
That could be a problem, because there are some times when you have plenty of time to prepare for the court, you have plenty of time to gather evidence, plenty of time to talk to witnesses, summons them, and so forth. And then they're not brought into the court.
Yeah. Okay, so in that situation, I've got an evidence bundle. It's 25 pages long. We've been through the evidence on pages 1 to 5, and now for whatever reason I have a mental blip and I move to page 32, right? And
25 pages long. Then you
okay. I go through pages 1 to 5, and then I go through to page 20. I forget what's in page 10 to 20, and go through the remainder. That could be problematic, because you could lose your case based upon.
You could lose your case because particularly the evidence between 10 to 20 is vital evidence that would support your case.
Yeah.
Right? And then it's not introduced, because here you're going, you're talking about all the stuff that's on page 1 to 5, and then 1 to 10, and then all of a sudden you hop to page 20, then you're talking about what's on page 20, but then after that says, okay, that's my case, then it goes the other side and they go cross-examine, but they haven't seen that other part from 10 to 20, and you haven't talked about it.
Yeah. So
these issues, because they were not raised, they cannot be adjudicated.
Yeah. And the whole point is that probably the best advice you can give to anybody who's preparing an evidence bundle is do it in the logical way in which you're going to introduce it. Think about how you're going to introduce it in the hearing itself. Now, it is true that, for example, you have an evidence bundle that's 25 pages long, and I'm going to introduce Mary as my first witness, and she can talk about everything on page 1 to 5. Right? I've now got Joe, who's my second witness, who can talk about things on page 1. He can talk about things on page 5. He can talk about things on page 10 and page 11 and page 12. Right? But he can't talk about anything else. Now, my third witness can talk about several other areas, and you've got to make sure that you put the witness in the right order in order that you
like
can
your
actually,
own,
yeah,
your own Coles notes.
yeah, you
Okay,
can go through
those don't go to the court,
and-
but you keep them as your own Coles notes.
yeah,
But your evidence book itself goes to them, so they know I refer to tab 5, page 4.
yeah,
Okay, and then this goes back to Mary, then this goes to Joe. You know, that's how you do it, like to make sure.
yeah,
And you keep in your Coles notes that page 1, Mary and Joe could address.
yeah,
Page 2, Mary could address. You know,
yeah.
so you're always very, very aware about when you can start introducing it. Okay.
Absolutely. And the
I've
whole
seen
point,
people who like I've been doing this for so many years. I just have to have my binder there and know where everything is in the binder, and I don't even have to write out questions. I know where everything is.
yeah. Well,
Okay.
I
And I've
prefer,
been doing that just off the top of my head. There's people who could do that.
yeah.
And then also too, for cross-examination, I just listen to what the other side says and I take notes. Then I automatically got a bunch of cross-examination
Well,
questions, and I could be there
me,
till dawn.
yeah, me, I prefer it electronically. So, hey, I want it on this screen here. You
Mm-hmm.
know, my evidence bundle on this screen here. I want to see the witnesses on this screen here,
Mm-hmm.
right? But then again, I do more tribunal than I do the court stuff.
Yeah, I've done the courts and the tribunals.
Yeah,
Okay. I've
and
had trials, small claims court trials on video.
yeah,
Okay. I think that drives the judges crazy, so they don't like them on video. Okay, so now they're asking for more people to come in person.
But again, actually, if you think about it, that you have given ignoring video, whether people will attend by video, that's another question. The evidence itself, if you think about the evidence in question, you've put all the bundles together in terms of your you've got the complete evidence bundle. It's been put into the court. You've given the other side their copy of the bundle, and all of your electronic bundles in color, but you do not have a color printer.
Mm-hmm.
Right. So other than taking it down to a printer who's got a color printer who's going to charge you $3 a page for the thing, and when you're printing 300 pages, that's a bit steep, right?
It's a pretty penny.
Yeah, you would probably be better off actually putting the evidence together in a bundle where you can actually show it in the court, much as this screen in front of us is here today, where you can put up documents and you can introduce documents through the screen, because most courts in the last 20 years have got television screens in them.
But the civil courts, they still kind of operate by the paper system.
Yeah.
Okay, so what we have to do is, I could think it'd be transferable to use a system where you can put all of your evidence into the court and have all of everything in a bundle so you know where everything is. Then everybody walk in with their laptops or their tablets, and the judge has his tablets, and you have a big screen on the front so everybody can see it. Okay, so if there's a witness speaking, we could see the witness speaking. Okay, and whether somebody's remote or whether they're visible in the courtroom doesn't matter. We can all see them. Okay, so I think that's going to be the wave of the future.
It is, and you're going to end up with, and again, for example, there would have been a day that if you had an accident, say you were traveling around in St. Catharines and you had an accident, you crashed into a car that was from Tennessee.
Mm-hmm.
Okay? Now you set the court date for the 12th of September, and you of course can turn up because you're local here, live in St. Catharines, but the witness from Tennessee, of course, is not going to show because it's quite a long way to come, and the police
That's a long walk,
and the court's not going to pay him to come.
Yeah.
But we've now moved on from there.
Yeah, we can always arrange to summons that person by a process server in Tennessee to make sure that that person can appear in a court, and we can file it in our court, have it notarized. Yeah. And then that person can appear by video wherever they are.
Yeah, exactly.
And then they can give their testimony that way. I think that's a lot easier for some people. Like, I think it was one hearing that you and I had where everybody was all over the place.
Yeah. Oh,
One
yeah.
was in Hawaii.
Oh, yeah.
Yeah, and I didn't expect them to walk in from Hawaii and come to the hearing.
And exactly. So the whole point is that you've got to, how courts run these days is a lot more adaptive than it used to be. And again, how the evidence is given is going to be slightly different. In a structure this way, I'm not so sure. For example, if you're looking the defendant in the eye and he's saying something, and you can kind of go from the expression on the face or how they look at something, you can say, oh, okay, so when you were talking about such and such, you were lying, weren't you, Mr. Defendant?
Were you telling the truth then, or were you telling the truth now?
That
I
kind
always
of,
did that.
because
Especially two contradictory positions taken.
yeah, because in fact you can tell by the facial expression often that a person's not telling the truth.
Yep.
Whereas on this type of screen, I could probably train myself to fool a person, right?
Yeah.
So you wouldn't know that outside it's beautifully light. It's a sunny July day. No, it's a freezing cold January evening.
Yeah. Exactly.
And it's dark.
That's like I just had a Zoom call. One of the participants in our Zoom call was sitting there in Florida, where it's nice and sunny.
Yes.
Okay. So I said, "Oh, that's nice." I said, "At least you don't have to shovel 5 feet of snow."
And of course he was saying, well, absolutely, that's why I came to Florida.
Yeah. He's got 2 homes, one in Toronto, one in Florida.
Yeah.
And this guy is hilarious.
Well, at this time of year, given the choice between Toronto and Florida, I think I'd be in Florida if I had to.
Chooses, right?
Yeah. Okay. So we talked about what happened if evidence is not introduced, because basically it means that you can end up with it not being considered by the court or tribunal. Let's move on to another area, impeachment evidence.
We started in that way, to talk a little bit about it, particularly when there's one guy saying this happened and another guy saying this happened, two opposing viewpoints.
Mm-hmm.
That if you have critical evidence to oppose the one who is different than your case, or in against your interest of your case, you can take evidence at that point, and then you can impeach. You can show proof of that person, that this was not true of what that person is saying.
Yeah.
It doesn't necessarily say that they're not telling the truth, but sometimes you can scare them a little and say.
Well, the example we gave earlier on, the example we gave earlier on about you saying it was a green car and I'm saying it's a blue car. Well, you could argue the difference between whether it's blue or green may well be the angle of the day, the sunshine, etc., etc., and how you see it. The fact that we both agree that it's a saloon car may be all the evidence the court needs.
Exactly. And especially if there's an expert report that comes out of it that might support the position of both people.
Yeah.
Right. So there's a lot of differences, but if there's too much of a polarization, sometimes it can go in there. A person claims that they were there on that night, and this is a place where you got to sign in.
Yeah.
Okay. So you get all the sign-in sheets and everything from that night. And where's your signature?
You're not going to impeach over a different color car.
Yeah.
Most of the time, right? But you might impeach over the question of, yes, I was there on the 14th of July. I signed the register. I played Joseph Smith at basketball and I beat him. I beat him thoroughly.
Yeah. And then I haul out the July 14th, and then I say there's no signature. And I ask him, can you show us court where your signature is here? Right? And there's no signature on there. Hey, I said, and you said that you signed in. Are you sure you're telling the truth here? Hey,
Well,
and they may be able to fish out when they last appeared at that particular location, which might have
yeah,
been the prior month. Hey,
yeah. Oh
so
well,
that's an example of your impeachment
I went,
evidence.
yeah, and then you kind of get the evidence, which is, oh well, I went in via the kitchen, which you kind of go, well, that isn't true. They don't let you in that way.
Yeah, exactly. I had someone hide me in because they knew I was going to end up going to court over this.
Yeah. So the point being is that when it comes to evidence, and it goes back to telling the truth, as I said, the fact there's a difference about what color the car is, probably minor differences. They're not going to really, it's not going to enter into the issue. They're not, so long as both witnesses agree that it's a saloon car that was there on that particular day, and they'll accept that you think it's a Toyota and I think it's a Chev.
Yeah.
The fact,
Then I admit I don't know anything about cars.
yeah,
Hey,
and
then you know about cars because you collect them, for
yeah,
example.
yeah,
Yeah.
exactly. And the fact that you think it's a Toyota, it's like, well, I've got a Toyota and that front light looks like my Toyota,
Yeah,
that
exactly.
kind of thing, right?
So sometimes
That's the
people
only,
would get into those sorts of
yeah,
things. Like he says, well, how do you know that this was the 14th? Well, to say, well, July 14th is my birthday.
yeah,
Hey, I knew that. Hey, or something like that. Or is that the date of my grandchild was born? Hey, and I know that that happened the same day. So there's a lot of different ways that sometimes you can get people to identify and to confirm dates and times.
okay. And the question about and then the other question, of course, is that having impeached a witness, you then, so I've taken your witness and I've basically just torn them to
Destroyed
shreds.
them.
Yeah. Now you've got an opportunity, of course, to actually
Re-examine.
rehabilitate them.
Yeah. Got to do a re-examination to try to get some kind of thing about honor, about different things, to try to get them into a situation where they could be telling the truth, but this might have been just a mistake in memory or some kind of thing.
Yeah. Yeah.
Right. So there's a lot of different ways that you would have to do that, but it takes a lot of training to do that. I've seen people who are new paralegals who get in when they start doing examination of their first witness, of their own witness, they start asking leading questions, which you're not supposed to do. You're supposed to ask open-ended questions to get the person to tell the story, but steer them enough so that they can tell the story the way you need it.
I plead guilty. I plead guilty to doing that when I was
I know. I've often said leading.
but I think I've learned now,
Yeah.
right? I've learned now because
Mhm.
basically what you've got to do is you've got to break that question down into a couple of break that question down and ask it several ways. And
Yeah.
you're right. Particularly if you love cross-examination, it's difficult to ask open questions.
Yeah, exactly. So the thing is, you have to get good at both because you're going to have to do both.
Yeah.
Right? If you're representing somebody at a hearing.
Yeah. All right. And okay, so and how you give that evidence, of course, is different whether you're giving evidence in chief or evidence in cross-examination.
Yeah, exactly. And you have to
And
be very, very careful to make sure things are done in a way. There is a lot of different tactics, a lot of different strategies you would have in terms of carrying on a case and
yeah.
presenting your case. Hey, a lot of people think we're like Law and Order, right? Or
Well,
they watch us on The Practice or something like that.
if
And
I were
people,
to
that's all it is.
so if I were to show you page 15 in your evidence bundle, what would you be saying about this? Right? And so you give your answer.
Yeah.
And now I want to take you to page 11 of my evidence bundle, and I would like you to read page 11, paragraph 2, sentence 3.
Yeah. If
Yeah.
you're my own witness, I usually present you something. I said, can you tell me a little bit about what this is?
Yeah.
Okay. And can you tell me the date of this document? Who wrote it? And what is it about? eh? And I said, is there anything pertinent about that document that you want to share with the court? Eh? So these things like that. And then if I'm cross-examining somebody with it, can you read this section here on this page 6 of such a tab? And I said, this little paragraph starting with, eh? And it's highlighted. Okay? And I get them to read that to the court. So they'll start to realize that whatever they came up with. And I said, does that show that the person can't do that? Or does it just show that the person must use precaution?
Yeah. But the point being is that in order to show that there's differences on the two sides, you often have to present two different pieces of evidence at the same time.
Yeah, exactly. And sometimes you're showing the same evidence, but you're showing it in a different way.
Exactly.
Like on each side, because your side may show one part of the page, the other side will show another part of the page, same page.
Yeah. So I'm only your evidence shows the top half of the page. You only showed the reply that said, yes, I will do that. I will be there on the 14th. But my evidence shows the original, the whole email chain. So when you said,
what did you actually agree to here?
Yeah, what did you exactly? So now let's look at the whole email chain. And so I see that on the 11th you stated, right, on the can you tell us what you stated on the 11th? Can you tell us what you stated on the 5th? Why would you agree on the 14th to this?
Yeah,
give a whole different story.
Yep. So try to get them to do this, like this is it, and it's very testy, but you have to be very, very careful when you go and approach these things. Okay.
Right.
It's always good to settle your cases rather than end up in trial, because it costs your client a lot of money to go to trial. Okay? Yeah. But however, if you can do a good case to go to trial with, okay, then you can do this, because I can do either or. Okay?
All right. I think we can kind of call it. I think we can call it quits at this particular point.
I think we need to,
because we've covered a lot about evidence, and realistically now, if you need to contact Invictus Legal, you can do so at 905-688-5598. Email Angela through angela@weareinvictus.legal, or myself at
weareinvictus.legal website, or the website
weareinvictus.legal. Okay. It's weird. It's very weird. So, and over to Angela.
Tin can here. So what you heard today on Spin Legal, whether it's this show or any others in the series, is not legal advice. And this is not legal advice. I'm not telling you how to run your trials. I'm not telling you how to present evidence. I'm not telling you what evidence is good, what evidence is not good. What I'm saying here is giving you examples of a common issue in law that people very commonly misunderstand. Okay? But if you have something going on of a legal problem, talk to a paralegal or a lawyer. Okay? We'd like you to come to Invictus, okay, if you have a question. Okay? But anyways, talk to a paralegal or a lawyer. Thank you.
All right. And well, this is episode 102, and we're signing out for now, and we'll be back next week. So have a great week, and don't get disturbed by the weather out there, and stay safe.
Yep.